Hello, everyone, and welcome to Uncivil Law. For today's case, we have Subway Franchise Systems, the Sandwich People, suing Canadian Broadcasting Corporation and Trent University. This is a decision from our friends up north, Ontario Superior Court of Justice. In this case, the Canadian Broadcasting Corporation ran a news story in which they alleged that Subway's sandwiches did not have as much chicken in them as was advertised, a dearth of chicken upon your house. And so we're going to read about this case and what the deal is with the chicken that crossed the road in Ontario. Let's read on. This case arises from a February 24th, 2017 broadcast of an investigative report on the show Marketplace, created, aired, and published online by the defendant, the CBC. The subject matter of the report was a comparison of chicken sandwiches sold by Subway and 4 other fast food chains in Canada. The CBC reported that unlike its competitors, whose sandwich meats were made entirely of chicken, Subway chicken sandwiches were reported to be only slightly more than 50% chicken. The products were tested for this report by an independent DNA testing laboratory run by Trent University. Subway has brought a $210 million defamation action against the CBC. That is a lot of chicken. It claims the investigation done by the CBC and Trent was faulty, that the show was defamatory, and that by airing and publishing the report, it caused business loss. The CBC and the university submit that the lawsuit is aimed not at vindicating Subway's reputation or recovering any real losses, but rather a chilling public discussion of an important consumer protection issue. They move to dismiss based on Section 137.1 of the Court of Justice Act on the grounds that it is a SLAPP suit. So we're going to learn about the Canadian equivalent of SLAPP, or at least the Canadian equivalent of SLAPP as it exists in Ontario, so we can learn a little bit more about how our brothers up north treat SLAPP suits. The anti-SLAPP provisions are not meant to create a forum in which to review the entire evidence that one or both of the parties would bring to bear if the merits of the lawsuit were being adjudicated. The criteria for dismissing an action under the law are a 2-part test, a public interest hurdle and a merits hurdle. For the first part of the test, the onus is on CBC as moving parties to establish that their broadcast covered public interest. If this is crossed, the onus then shifts to Subway as the party seeking to litigate that they have substantial merit and that there is no valid defense. So in broadest paintbrush strokes, this is very similar to what goes on in much anti-SLAPP law in the United States, part of a 2-part test. As to the first step, the court must consider whether the Marketplace report was a broadcast relating to public interest. There is no fixed definition of public interest. It is in some sense a judgment call for the judge hearing the case. The Court of Appeals has made clear in deciding what is in the public interest requires an objective assessment. So let's get that straight. It's an objective assessment to which there is no established test. So it's objective, but the trial court has to make it up. Okay. The Marketplace report dealt with the ingredients of sandwiches sold by popular fast food chains. It relayed the DNA test performed by Trent Laboratory at Trent University, which indicated that 2 types of Subway chicken products, the chicken patty and chicken strips, contained significantly less chicken DNA than other chicken products tested. It is not controversial to say the public has an interest in knowing the ingredients and percentages thereof of the food they ingest. Furthermore, the Marketplace report contains a quintessential consumer protection issue. There are few things in society of more acute interest to the public than what they eat. To the extent that Subway products are consumed by a sizable portion of the public interest in their composition is not difficult to discern and is established on the evidence. People got to know more about that chicken, man. It is definitely something in the public interest. I want to know where my chicken's at. As to the merits test is divided into 2 inquiries. Broadly speaking, the statute speaks to potential merits of the lawsuit. The section provides explicitly to the merits of the proceeding, in which I take, as the court, to be merits of the claim the plaintiff must prove. A different section addresses the absence of any valid defense, which I take to mean the absence of an affirmative defense. The first step required by the statute is for Subway to show its claim has merit. Now, let's get into exactly what Marketplace allegedly said about Subway. The Marketplace report was promoted by CPC as a chicken challenge. It was categorized as an investigative contest comparing various chicken products sold by Subway and others. Subway identifies the following statements as harmful. So everyone's wondering how much chicken is really in your chicken. What did you find out in our chicken test? Most of the samples came back as very close to 100% chicken. Any guesses as to which one of the samples had the least amount of chicken? Sample D. Our DNA test shows that it could be less than 50% chicken. Sample C. Well, our DNA test shows it only more than 50% chicken. Who made both C and D? Subway. Subway strips and oven roasted chicken could be only about 50% chicken. And guess what? The rest, mostly soy. Soy in my chicken? The broadcast of the Marketplace report was accompanied by an article. Even more statements about Subway. Let's read them. DNA test shows Subway sandwiches could be just 50% chicken. A DNA analysis of the poultry in several popular grilled chicken sandwiches and wraps found that at least one fast food restaurant isn't serving up nearly as much of the key ingredient as people may think. Looks like chicken, tastes like chicken, but is it really all chicken? Yet even more statements, this time on Twitter. Get ready, East Coast. How much chicken is actually in your fast food grilled chicken? At CBC Marketplace will tell you next. Any guesses what else could be in your chicken? If you ordered a chicken sandwich at Subway, it might only be about half chicken. More from at CBC Marketplace investigation. DNA tests show Subway chicken sandwiches contain just 50% chicken. Order chicken instead of red meat, you might be getting less real chicken than you think at fast food restaurants. Is your chicken actually chicken? They definitely wanted to make a point in their hawking of the story, that's for sure. Counsel for Subway submits the meaning of the publications was clear and understood to a global audience. News media in Canada and the United States reported the allegations. Yet more statements about the chicken. From CBS Los Angeles, the result shows that oven roasted chicken patty is 53.6% chicken, while the sweet onion chicken teriyaki strip is 42.8% chicken. From Breitbart News, Subway chicken sandwich contains only 50% chicken. NBC 12 on your side, Virginia. Test shows that chicken sandwiches from some places may contain only 50% chicken. Munchies from Vice. Subway oven roasted chicken was allegedly only 53.6% chicken. Subway's sweet onion chicken teriyaki strips turned out to be only 42.8% chicken. Subway claimed it supports evidence that says it demonstrates that its chicken products are substantially more than 50% chicken. Subway's evidence is that the chicken in its chicken sandwiches is made by a third party, Grand River Foods, to Subway specifications, and the chicken products contain only 1% or less of soy filler. Subway's in-house food scientist deposed that Subway has verified its specifications are followed by obtaining periodic product testing results from Grand River. She went on to state that after the broadcast on Marketplace report, Subway had its chicken products tested by independent laboratories Maxam and Elisa Technologies. Those independent labs verified Subway's chicken products are in the range of 1% soy. So Maxam apparently is both a magazine and, in a slightly different spelling, is a lab that will test the quality of your chicken. Okay. Subway's record also contains much evidence that the reporting had any number of warnings or red flags regarding what it alleged was faulty testing reporting by Trent, but failed to follow up on those warnings. The laboratory tests performed at the broadcasting company's request formed the basis for the reported information about the supposedly high soy content of Subway's chicken products. These tests provided a DNA analysis of chicken products from the various fast food restaurants, and they were not corroborated by other information. The record submitted by Subway contains a substantial amount of evidence indicating that the laboratory tests were of limited or no value in determining the chicken content of the products. Dr. Schubert, also deposed, stated that, separate from what he identified as substandard methodology used by the university, the laboratory tests did not yield the conclusions that the broadcasting attributed to. To make a case liable, Subway must establish three elements. The impugning statements refer to Subway, statements were published or broadcast, and the statements are defamatory in the sense they tend to lower Subway's reputation in the community from the viewpoint of a reasonable person. The test for determining whether statements are defamatory is objective. The question of defamation does not turn on the intent in broadcasting or publishing the impugned statements. Courts in Canada have pointed out the threshold for finding defamatory intent is not particularly high.
Hi-yo, chicken on a rock. Hi-yo, chicken on a rock. Hi-yo, chicken on a rock. Well, I had a little girl in Donny Bay. Hi-yo, chicken on a rock. And did she make a fool of me? Hi-yo, chicken on a rock.
This is Uncivil Law, in case you didn't know. We do shit like that. That's how we roll. Thank you for being part of the Uncivil Law crew. It would not be the same without any of you. The case law on libel provides that the original author will be liable for third-party republication when they convey the same defamatory message as the defendant's original statement, whether or not they are stated to be verbatim quotes. This is the case regardless of whether further publications engage in slight alterations to the republication, as long as the sense of the original publication is still the same. On the state of the record, Subway has successfully passed at this stage. While the court makes no definitive finding, there is considerable evidence to suggest the false and harmful nature of the information conveyed to the public in the report. So far they're saying that yes, it did harm Subway, and yes, Subway has shown that they actually do have legitimate interest. This isn't just slap. So now we're going to go on to the successful ability of defenses, whether or not they're defenses for them. There is considerable divergence between Subway's evidence and that of the CBC regarding the diligence of CBC's effort to be accurate. CBC says it chose Trent, a reputable university laboratory that operates independently and was open to being scrutinized by outside experts. CBC and Trent contain that Trent ran multiple tests on the products and those of its competitors and consistently found that Subway's chicken was an outlier in having substantially more plant DNA than others. CBC submits that it gave Subway ample time to respond to the report before it went on air. In an email sent from Subway to the CBC less than a week before the investigation, Subway provided its response to DNA results and forwarded it to CBC several weeks previously. Subway Canada cannot confirm the veracity of the results of the lab you are conducting. However, we are concerned by alleged findings you cite with respect to the proportion of soy content. Our chicken strips and oven roasted content contains 1% or less of soy protein. We use these ingredients in the products as a means to help stabilize the texture and moisture. All of our chicken items are made from 100% white meat chicken, which is marinated, oven roasted, and grilled. Finally, all of our chicken items, and every item on our menu for that matter, are inspected by the Canadian Food Inspection Agency, and all of our offerings meet or exceed standards. This is true for all Canadian and US labeling requirements. Counsel for the CBC submits this exchange as significant in asserting its strength of responsible coverage. They analogize the response, or lack thereof, to that of a different plaintiff, in which the plaintiff had refused to respond to allegations of past criminal conduct. CBC's counsel submits that providing Subway with an opportunity to respond with a live interview in which Subway declined fulfilled its journalistic obligations to give all sides of the story to be heard. On the other side of the coin, Subway contends CBC had numerous warning signs indicating that Trent Laboratory was unreliable. CBC knew the accreditation of the laboratory by the ISO was important, but declined to have an ISO accredited lab conduct the testing. Trent had not done this type of testing before. Dr. Robert Hanner, an expert retained by the CBC, expressed concerns both before Trent started doing the testing and after Trent delivered its preliminary analysis about whether Trent could determine the percentage of chicken in a sample. Testing took months to complete, with limiting excuses from Trent as to why. Subway disputed the tests, and CBC spoke to a confidential source from Grand River regarding the composition of chicken sandwich products. That source did not corroborate the results of the test. The record reveals that once CBC learned of Subway's objection to the test results, its personnel redoubled their efforts to verify. In a transcript of a telephone call between CBC and Matthew Hayden of Trent, CBC learned that it varies enough that you couldn't be able to report accurately 50% because it can go plus or minus depending on water weight. The rewarding of the report was framed to reflect this potential margin of error. Subway has mounted a weighty attack on the reportage. Its evidence on this motion comes to 14 volumes, including 10 affidavits from 8 witnesses. Having said that, Subway has not really countered the crux of CBC's responsible communicative defense. Therefore, I am satisfied that the jury could not reasonably conclude that CBC's defense of reasonable communication would not succeed. So basically here the court is saying, look, there was some evidence to the contrary, but at the same time, they took that evidence to the contrary and they engaged in further investigation to determine whether or not their initial reporting was accurate. So they took your concerns and they put them into the mix, and they also offered you a chance to be interviewed, which you declined. So they engaged in responsible reporting practices. They took your concerns, they double-checked the results, they offered a chance to correct the record, they basically did things that they thought were prudent. And so they engaged in responsible reporting. So there's no liability as to CBC. That makes sense. Therefore, the court says CBC's motion is granted. Subway's action against CBC is dismissed. However, Trent's motion is dismissed. Subway action against Trent, the university, will proceed on its course. So we didn't really cover the depth of the issues against Trent specifically, but basically the allegation is this, in short, that Trent's reporting was inaccurate and they knew it to be inaccurate and they engaged negligence. So CBC is off the hook because they engaged responsibly by looking to a third-party tester. The third-party tester gave them invalid results. So they're saying, look, you can go back to trial and try to hold the university responsible. Now, whether or not at trial they'll ultimately be held responsible, or whether or not what practices they engaged in will found to be sufficient, we don't know yet. But we do know that there's enough for this to go forward, so the anti-SLAPP issue will not bar the lawsuit against the university for any improprieties or negligence on their end. So that is the end of the case of Subway versus Canadian Broadcasting Corporation and Trent University from our friends up north in Ontario. In this case, we learned that Canadian Broadcasting Corporation did a test of various chicken-based fast food products, and according to their testing from Trent University, Subway's products were found to be not that much chicken. But we also learned from the findings that this report may not be accurate. We learned that there were signs that Trent University may not have known what it was doing and may have provided CBC the wrong information. However, we also learned that CBC engaged in responsible reporting and that they attempted to double-check their results and verify the results. So, no liability to CBC. It engaged in responsible reporting, but there might be liability as to Trent if they engaged in negligence and by doing so gave the wrong information which caused damage to Subway. So this will have to go back to trial for further findings to find out if Trent was negligent or otherwise irresponsible, and that is the end of the case for now.
Hi-yo, chicken on a raft.